Okay, Tony, are you ready?
Judge.
Let's go on the record on DC 223316, Donna Deloney versus Clemisha Fleming. Counsel, make your appearances.
Jason Carr for the plaintiff.
Morgan Reinhart for defendant.
And we have observing today Judge Craig, who is our new associate judge. She's observing today. So if you guys want to go ahead and get started.
Yes, sure. This is defendant's motion for summary judgment. It is based on a limitations period in due diligence efficiency. Defendant is seeking summary judgment based on plaintiff's failure to exercise due diligence to serve the defendant within the limitations period. This concerns an accident that occurred on April 7th of 2022, of 2020 in Dallas, Texas. And so the limitations period was in April 7th of 2022. The plaintiff initially filed suit on March 25th, which is about 13 days before the limitations period. The defendant was not served until April 21st, 2023, which was more than 12 months after the limitations period. And we do not believe that the plaintiff has provided sufficient evidence to support continued due diligence to attempt to serve the defendant during that time. So plaintiff must not only bring suit, but also exercise due diligence to serve a defendant during the continuously in order to have the service revert back to timeliness in the limitations period. Overall, the plaintiff has exercised 11 attempts to serve the defendant within about a 12-month period. During that time, the case was set for dismissal for want of prosecution for a hearing on 4 occasions. And actually in March of 2022, an order was entered to dismiss the case for want of prosecution for failure to serve the defendant. Before the hearing on plaintiff's motion to reinstate was held, the plaintiff did end up serving the defendant. So beyond just the general scope of the case and the time period it took to serve the defendant and the efforts of service, there are some specific periods of delay that have gone unexplained. Under the Supreme Court's precedent, every period of delay has to be explained, not just the overall service period. And so specifically, there's a 64-day gap between the plaintiff's 5th and 6th attempt at service, a 61-day gap between when the plaintiff ordered a skip trace and their first attempt to reach the defendant directly by phone, a 73-day gap between the plaintiff's second and last attempt to call the defendant by phone and their attempt to serve the defendant for the 7th time, a 55-day gap between their 7th and 8th attempts at service, and a 45-day gap between their 9th and 10th attempts at service. These specifically have gone unexplained in the plaintiff's response. The only explanation given is a general conclusory statement that during these time periods, overall, and then those specific time periods, they tried to diligently perform searches online with public data and social media. However, there's no specifics about this. They just said they regularly perform these searches. There's no information provided about how much time was spent, how regularly that was, daily, monthly, weekly, what sites were even looked into besides just public data. And so I think the overall record of 11 attempts at service within a 12-month period, the fact that this court had already dismissed this case for want of prosecution, and then these specific instances of completely unexplained delay should lead the court to find that the plaintiff failed to exercise due diligence to serve the defendant within the time period. And so therefore we're seeking summary judgment.
Case, there's a lot of case law on this issue of due diligence.
Yes, Your Honor.
And the law has not been always incredibly consistent. What case do you feel most strongly supports your position?
So actually, I think the plaintiff and I are both citing the same case. It's Proulx, Proulx. And let me find the citation for you if I have it somewhere easy. So in that case, let me find you the citation first before I go off. Proulx v. Wells, it's 235 Southwest 3D 213. the Texas Supreme Court case from 2007. In that case, the plaintiff had attempted to serve the defendant 37 times at 5 different addresses over the course of 9 months. So you're averaging about 1 service attempt a week. In this case, we only have 11 service attempts at 8 addresses over the course of about 12 and a half months. So about 1 service attempt every 5 weeks. Also in Brooks, the plaintiff hired a private investigator, which was done about 2 months after getting the citation. The plaintiff in this case also hired an investigator, but it was 10 months after citation was issued. And also there is I believe the plaintiff might raise concerns that the defendant was trying to evade service. A similar concern was raised in Brooks. But in Brooks, the plaintiff tried to attempt substitute service by other means, given that concern. In this case, there was no attempts at all for substitute service in any manner, any form. And so I think the difference in those cases with, again, 37 attempts versus about 11, and then the other efforts expended is pretty striking.
Response? Mr.
Sorry,
Carr, response, Mr. Carr?
Yes, Your Honor. This case is analogous with Prue in that we made the similar efforts and similar attempts. The 37 attempts in Prue are made mostly at the same addresses where they believe the defendant resided. We followed the same exact pattern. And the defense has cited in their reply that a flurry of attempts at an address that you know to be wrong is not evidence of efforts. And plaintiff wasn't trying to do that. As soon as we found out that an address was not the correct address for defendant, then we didn't try to serve them again there, and we tried at a new address. So we stopped, located a new address, and then continued trying to serve defendant. Also at play in this, as it is in Prue, there were concerns that the defendant was attempting to evade service. However, if Your Honor looks at the timeline provided by both our process server and our efforts as well, that timeline lines up with our attempts to communicate with both defendant and her insurance provider during those gaps, as defendant has stated they are. Those are times when we were speaking with the defendant and her insurer, and they assured us we're doing everything we can to do this. Here's the address that you can serve her at, and so we were acting in good faith, attempting to obtain service, and for that reason, substitute service was not sought. As soon as it was apparent that both the defendant's insurance provider and the defendant herself were lying to us and not cooperating, we hired a private investigator. In that time, we had already been doing skip traces, and then we pushed forward with that. And so we've made multiple attempts at all the addresses that we could. We tried multiple addresses, and we tried more addresses than in Prue. Prue was also dismissed as well, and then was reinstated. And if Your Honor looks at the timeline for our efforts to serve defendant, even after reinstatement, we had a date where defendant would be at a hearing for her criminal for a separate matter. And even then, we were still performing those searches and found a new address for defendant that ended up being the correct address. And so that is additional evidence of our diligence. And we believe that the motion should be denied on those grounds, that defendant has not provided a single case that is analogous to this one, where it amounted in a motion for summary judgment. Our efforts in this case are similar to Prue, and Prue, the Supreme Court overruled the Court of Appeals and found in favor of the plaintiff. And for that reason, we asked the court to do the same here today.
So let me ask you, in this Prue case, was that a summary judgment appeal, or was that a trial court, like a jury trial appeal?
Your Honor, I believe it was summary judgment, but I'm actually not certain of that.
I'm not sure either, but I believe it was summary judgment as well.
So I guess the reason I asked, this seems to me to be kind of a ideal situation where I haven't had a whole lot of these submitted actually to a jury, but if you have your pattern jury charge, negligent pattern jury charge, PJC 14.1 indicates that there is a question you can ask, tolling by diligence and service. Did Paul Payne or someone acting on his behalf exercise diligence to have the defendant served? The standard of diligence required is that diligence. So there's an actual, I think this really is kind of a fact issue. I don't think that there's conclusive, it's been conclusively proven that diligence was exercised, but I do think there's at least a fact issue there. Assuming that it's properly pled by the defendant when it goes to trial, or if this case goes to trial. So at this point, I'm going to deny the summary judgment. I do think that if it's pled and requested at trial, that question would be appropriate, because I do think that there is probably a fact issue here. Anything else you guys want to chat about?
That's everything, Your Honor.
No, Your Honor.
All right. Have you guys gone to mediation on this case yet?
No,
We have
Your Honor, we're
not.
pretty early.
Depositions are set. We're pretty early.
Okay. All right, guys, you have a great rest of your day, and we'll see you on the next one, okay?
Thank you, Your
Thank
Honor.
you, Your Honor.
Thank you. So we have one more hearing this morning at